They are breaking in this Derek Chauvin trial. We've been listening to Dr. David Fowler. He's a former chief medical examiner from Maryland, and there was sort of a long period of time going through his credentials. And then they started to break down the autopsy report. And, you know, much of what he was talking about was the other factors that he believed contributed to George Floyd's death. He talked about his enlarged heart. He talked about his arteries, narrowing of his arteries. He has not gone in depth with his drug use of fentanyl and meth, but I presume that that's going to be where a lot of the questioning is going to be going after the break. And he's essentially arguing that there were a number of additional contributing factors, not just his what they're calling positional asphyxia, which is, you know, having a knee on your neck. That his health was a major contributing factor. Vlad.
Yeah, Fowler also testified that if someone suddenly dies from narrow arteries, they don't always have damage to their heart muscle. That was an important detail, I think, because last week a state medical expert told the court that there was no damage that was apparent to him when he looked at George Floyd's heart. So that I thought was sort of an interesting detail. But you're right, he didn't go into great detail about the methamphetamine use, but he did suggest that it perhaps played a role specifically as it relates to these contributing factors that you talked about, Anne-Marie. He said fentanyl intoxication, recent methamphetamine use, and also hypertensive heart disease. Fowler says that those were significant, his words, significant in their contributions to, quote, Mr. Floyd having a sudden cardiac arrest. So that was sort of interesting. You know, I think the jury, as we have noted all throughout the last 2 weeks, has been noting a lot of what these experts are saying. This morning, we heard from Jamie Yuccas, who said all throughout the course of yesterday and all the days, the jury is furiously writing notes down. So let's play while we wait for our legal experts to join us. That first soundbite of Dr. Fowler talking about the certification of death.
What is the first part of the certification of death?
So the first part here, the cause of death, is cardiopulmonary arrest, complicating law enforcement, subdual, restraint, and neck compression.
So it's interesting, Anne-Marie, that he does say in that comment, law enforcement, subdual, restraint, and neck compression, but the defense attorney has chosen not to focus at all on that part of his analysis and to talk about some of these other issues that Dr. Fowler has raised. Did we say that we had Rikki?
And he also, we do have Rikki.
Okay.
He also talked about carbon monoxide exposure, and I thought to myself, well, he would not have been, you know, exposed to large amounts of carbon monoxide if he wasn't pinned to the ground near the back of a vehicle.
Good point.
But yes, we do have Rikki, CBS News legal expert and analyst. So Rikki, let me just get your overview now. What do you make of this particular witness?
Well, first of all, we have to remember how well qualified he is. So we have to start with that. And he is another expert witness in the school, if you will, of Dr. Chauvin, the pulmonologist, and Dr. Rich, the cardiologist, who is a teacher. I don't know at this point, but we will find out from the reporters in the pool who will send out notes. I don't know how much attention the jurors are paying to this. I would assume a lot, because the detail about the heart, the detail about what happens to the systems of the body has really been quite extensive. So I don't think to us and to our viewers, I don't think to us that this testimony is surprising. We expected it from the defense, that they would call a witness or more than one witness that would say that the cause of death for George Floyd was not the intervention of Derek Chauvin and the police, but it was, in fact, this coronary heart disease, this hypertension exacerbated by drug use. And that is really precisely what we're hearing now. One other point, Anne-Marie and Vlad, that I'd like to make is this is interesting to me in particular because I have not heard before, in all of the years that I tried cases or have covered cases for national television, I really have never heard about this entire forensic group that he is a member of, that they would all participate in reaching a conclusion about cause of death. And if he is able to testify later, we don't know that he is, I'm sure it will draw an objection, that the others in this peer group review also agree with his conclusions about cause of death. I think that's very powerful testimony for the defense that is only, remember, looking for one juror. They're not looking for 12. The prosecution needs 12, the defense needs 1.
Rikki, stand by. Well, let's bring in also Jessica Levinson, another CBSN legal analyst who's joining us now to break down what we've been watching. And Jessica, you and I just communicated briefly before you came on air about this doctor, David Fowler, and perhaps our viewers are not aware, but our station in Minneapolis has reported this, so has the Washington Post, that Dr. Fowler is involved or was involved in a case very similar to this, although not the same. A young man named Anton Black in 2018 in Maryland was seen on video struggling with police officers. Police were investigating a possible kidnapping. He was 19 years old, young black man. Police wrestled him to the ground. The young man, Mr. Black, later died. No officers were charged in his death. The Black family said in a court filing that this was chillingly similar. This expert that you're seeing now on our screens is the former Maryland, he's a former Maryland medical examiner who deemed Mr. Black's death an accident, and that's a determination that his family has pilloried now in a federal lawsuit they filed back in December. So the question, I wanted to set that context for our viewers because I was curious if that was something the prosecutors could bring up when they begin their cross-examination, and you explained that there are two, the legal way to do it and the way that it would probably be done is how?
So I think this is what would have happened, is that we've seen when the jury is out of the room that the attorneys will have these motions, basically how much evidence can the jury hear? Can they see this document? Can they hear from this witness? And so there would have been a ruling before he came on the stand to determine, can the prosecution bring this up on cross? And I believe that the forks in the road are, yes, if it can demonstrate bias, but no, if it's just an allegation. Because we do need to be careful that allegations in and of themselves are not proof of bias. Allegations are proof of one person or one family filing an allegation. And so depending on where that case is, again, if it's just at the phase of a complaint, and it's not at the phase of being able to show bias, then I do not think it would come in. And I think probably it won't because there's so many experts out there. It would be really curious to me that the defense of all the experts in the world would decide to pick an expert where the prosecution would be able to question on that particular case. Because again, I think you just laid out, Vlad, really well the similarities in the cases. One could see very easily how that would just demolish his credibility in the eyes of the jury.
I want to play a little bit of the testimony just in case people missed it. I think that this sort of sums up the conclusion of Dr. Fowler. Can we play SOT 3?
In my opinion, Mr. Floyd had a sudden cardiac arrhythmia due to his atherosclerotic and hypertensive heart disease, or you can write that down multiple different ways. During his restraint and subdual by the police, or restraint by the police. And then his significant contributory conditions would be, since I've already put the heart disease in part 1, he would have the toxicology, the fentanyl and methamphetamine. There is exposure to a vehicle exhaust, so potentially carbon monoxide poisoning, or at least an effect from increased carbon monoxide in his bloodstream, and paraganglionoma, or the other natural disease process that he has. So all of those combined to cause Mr. Floyd's death.
So, the prosecution put on a number of experts and even non-experts that commented on George Floyd's health status. I think they described his heart as having a slight thickening versus the description here, which was an enlarged heart. So they had the prosecution had, expert after expert after expert suggesting that, yeah, he had some health issues, but, nothing that would lead to his death. Yes, he had this interaction in 2019, but you know what? He didn't die in 2019. I'm wondering if the defense is going to need to come back with that level of ferocity, for lack of a better word. Are they gonna, is this, and we don't know, I don't know who else is expected to take the stand today, but is this one medical expert gonna be enough to combat all that we heard from the prosecution? I guess I'll ask Rikki, and then Jessica, you can weigh in afterwards.
One expert could be enough for the defense, or 3 or 4 or whatever the number of experts, because I go back to right where I just left off. The defense is looking for one juror to hang this jury, because the result of having a hung jury is it gives not only the defense an opportunity to have a second trial, but far more important, it gives the defense an opportunity to enter into a plea bargain, and whether that would be even for the top count with the suggested guidelines instead of aggravated, enhanced guidelines, or whether it would be to murder 3, which was reported that was what Derek Chauvin offered to plead guilty to in the first place. I also want to go back to a moment of agreement, as usual, with Jessica, who I think is such a wonderful authority. But I totally agree that this other lawsuit, I don't see how that comes into evidence, because if it should, it really is not the point where we should be talking about a lawsuit that has been brought by an aggrieved family. Well, there are lots of lawsuits. We live in a litigious society. So it's one thing for the Washington Post or any other paper or us to talk about it. It's another thing for it to come into evidence before a jury. And then if I'm the prosecutor, I come back and redirect and say, well, how many autopsies have you done where you found the result to be a homicide? And I'm sure they're well into the thousands. So the fact that there is one particular homicide that is in question in a different situation, albeit somewhat similar, but a different situation, I think that would be reversible error if there is a conviction and it went up on appeal.
Jessica, did you want to chime in?
I agree with everything that Rikki said, and she really helped flesh out that point of the expert. And I would also just emphasize her point that the prosecution's goal and the defense's goal are so different here. The prosecution has to get unanimous verdict, all 12 saying yes beyond a reasonable doubt. So is one expert enough? It might be if it can put enough doubt in the mind of the one of the jurors. And as Rikki said so eloquently, that's the main thing.
So the defense also asked the doctor to define the term homicide as it appeared on the birth certificate. Let's play some of that.
Death certificate.
Death certificate. Thank you, Anne-Marie. Not birth certificate.
It is to be emphasized that the classification of homicide for the purposes of death certification is a neutral term and neither indicates nor implies criminal intent, which remains the determination within the province of a legal process. Regardless of what the medical examiner puts on a death certificate in the way of a manner, the legal system can and will act in a completely independent and different format.
So he pointed out, Rikki, that intent to cause death is a common element to determine that someone's death was a homicide. He's a doctor, not a lawyer, so help us understand what he's trying to explain in that answer to Mr. Nelson.
It's a difficult issue. It always is really thorny, Vlad, because when a medical examiner writes down accident and then the prosecution goes forward with a homicide prosecution, be it murder or manslaughter, the prosecution hates when and rightfully so, hates when the medical examiner's death certificate says accident. Now here we have the opposite. Here it's a medical examiner's conclusion, and one understands from all of the evidence we heard in the prosecution case that the medical examiners, there were two who testified, and the other medical experts all say that but for the intervention of the police in the subdual restraint, that is restraint while being subdued, that but for that they believe George Floyd would not have died that night. That's the language that we heard over and over again. So the medical examiner here, Dr. Fowler, is correct that the medical examiner's conclusion does not mean, therefore, that the jury must conclude that it's a homicide, meaning a murder 3, a murder 2, or a manslaughter 2, which are the charges here, but that is, in fact, a court determination made by a jury. That's very difficult for a jury to understand, and because they say, well, I see the death certificate, and it says homicide. So that means that something that the defendant did caused this death. So it's a defense lawyer's dilemma, as the opposite would be if it said accident. It's a prosecutor's dilemma.
That is so fascinating. I never thought about that because I was listening to that, and I sometimes tend to just think of myself as what if I was sitting in that as a juror, and I was like, well, I don't get it, because if the medical examiner says this is what happened, then what am I supposed to think?
Well, I agree with you. What does one think? Also, keep in mind this, because this is so strangely charged under Minnesota law. Derek Chauvin is not charged with intentional murder. He's charged with unintentional murder. He's charged with felony murder based on the underlying felony of assault. So if the jury finds that he intended to assault, that is, put his knee for 9 minutes and 29 seconds on the neck of George Floyd, that's the crime. It's not that he woke up that morning and intended to go out and kill someone. And it's not that even when he put his knee on George Floyd's neck that he intended to kill George Floyd. In fact, clearly the contrary, or you couldn't have the murder 3 charge of a depraved heart or mind, and you certainly wouldn't be having the manslaughter charge, which really is dealing with negligence, having to do with not appreciating what the consequences of your actions are. So this homicide on the medical examiner's certificate and the definition having to do with intent, when we're dealing with a crime that is not an intent to murder, no wonder these jurors could be, I'm not saying they will be, but they could be confused.
So the doctor also testified a little bit about George Floyd's drug use and the impact that it could have on his heart, narrowing his heart's arteries. I want to play some of that sound.
Well, in this particular case, methamphetamine, which was present in Mr. Floyd, has been associated with earlier onset of narrowing of the coronary arteries by atherosclerosis. He had significant narrowing of all of his coronary arteries close to their origin, which really is consistent with all of his heart, unfortunately, being subjected to reduced supply, not just a portion of his heart, but the entire heart.
So I, like you, Vlad, am not a trained attorney, and so I think of myself as a member of the jury. And I thought to myself, you know, aren't police supposed to be trained to interact with people who have various health issues? You would think that that would be sort of one of the things that would be factored in their training. But I'm wondering, Jessica, how damaging is this testimony for the prosecution's case?
Well, I think it was, as Rikki said before, it was always going to come down to this moment of being a battle of the experts and medical experts about what the substantial cause of George Floyd's death was. And that's frankly because I don't think the defense has anywhere else to go. There's really no other place to find some light and try and make an argument. Now, how persuasive will that be? Again, the defense has a much lower, essentially, burden here, threshold that they have to pass. Now, what the defense is trying to say is you have to consider everything else that's going on. You have to consider that George Floyd had a compromised heart. You have to consider that his heart was also under the strain of drug use. Now, considering all of that, are we absolutely sure, beyond a reasonable doubt, that Officer Chauvin's knee on his neck for 9 minutes and change was the substantial cause of his death? And that's what I think we're going to see from the defense for the remainder of their argument here. One point with respect to the death certificate, and I think this is such an important question, the jury sees the word homicide and they think, okay, well, somebody who's an expert said this is homicide. This is a little bit of a situation where you use the same word in different contexts and it means totally different things. So for instance, I teach my students about something called the Court of Appropriation. One of the elements is you have to satisfy that a defendant used plaintiff's name or benefit for their use or benefit. But use or benefit in this context doesn't mean if you're using them in a news article or in a television program or a piece of art. And so it just has a totally different meaning from the one we're used to in that context. And that's what I think the attorneys are going to have to try and show is that, yes, same word, but two totally different paradigms for the meaning of it.
I was listening also yesterday when Eric Nelson called to the stand the retired police officer, Minneapolis police officer who interacted with George Floyd the previous year. And I don't think we got a chance to talk about this, Rikki, because it happened after our show was on the air. But it's interesting because Anne-Marie just said, well, aren't police officers generally, either trained to render medical aid or call for EMTs? And in that interaction with that retired Minneapolis police officer, there was an EMT that was there because he thought that, because George Floyd said, or maybe he surmised, that there was a medical condition at play. And in that situation, the EMT was there and George Floyd survived. I was trying to understand why Mr. Nelson chose to show that video, given that the judge was really narrow about how the jury could, what's the word?
I think, Vlad, sorry not to cut you off, but I think court may have resumed.
Oh, okay. All right. So I guess we'll get to this question
back into
tomorrow,
the courtroom.
Rikki.
Thank you, ladies.